Hi, I'm Elizabeth Talbot, and this is Matthew Talbot, and we're with the Talbot Law Group in Walnut Creek, California, and we're a trust and estate law firm. And today we're going to talk about the trust generally, and we're going to talk about the revocable trust, which is the standard trust that most people will put together during their lifetimes.
That's correct, and we just wanted to try to provide some information to people who might be stressed out or nervous during these uncertain times with the coronavirus pandemic. So today we're talking about the trust, and this is part of a larger estate planning package. We want to give you further information about these types of documents. So most trusts that people put together are revocable trusts. There are also irrevocable trusts, but those tend to be more complicated, and in this video we're just going to focus on the standard family revocable trust.
And revocable means you can make changes to it or just revoke it or do away with it altogether.
That's correct, and that's important because these documents are designed to last through your entire life. And so sometimes people come back to us 20 years after they've done the initial trust and they want to make amendments at that time. And so the revocable nature of the trust is very important. Now, another important aspect to a trust is that you're naming a person or persons to manage your assets if you're unable to do so. And that would be either due to mental incapacity or death, okay? And I know it's a little sad to think about these types of things, but this is what we have to focus on. And so when you're appointing someone, we recommend that you appoint a single person and not co-trustees, because when people appoint co-trustees, it can sometimes lead to fighting or litigation amongst them. When you appoint a single person and you're no longer able to manage your own affairs, that person will go to the bank with the trust and the documentation showing that you can't manage the assets, and then they will be able to take over.
So initially when I set up a trust, or like me and you, we have a joint trust together, we are the trustees of our trust. And while either of us is alive to take care of that trust, no one else is of course going to handle our assets. But we name someone, the successor trustee, in our case it's Matthew's brother, to take care of our assets if for some reason neither of us can. And that could be because we were hospitalized for a long period of time. It could be because later on in life one of us develops dementia, or one of us or both of us have passed away.
That's correct, and so it's important to have people that you really trust acting as your backups, so that when the time comes, they'll be able to assist. And of course, if they're managing your assets, they're legally required to manage them in your best interest, okay?
And in our next video, we're going to talk about the other important aspect of setting up a trust, which is setting it up in the most prudent way possible so as to avoid litigation after you pass away.
And so another key aspect to a trust is the distribution provisions. Now, if you do absolutely nothing, the legislature assumes a distribution provision for you. And this may work for some people and it may not work for other people. So when you put a trust together, what you are doing is you are telling the world how you want your assets distributed. If you have distribution to children, then you can set up a special trust for their care, and you can select the age or ages at which they receive their funds. That way the money is protected and managed by someone else, especially if the children are very young, and it has to be managed solely in their best interest. You can also set up distribution not just to people but entities. So if there's a religious organization or a charity, you can put that in there also. So that's the second very important aspect to setting up a trust, controlling your distribution.
Thank you very much.
Thank you so much.